Hey everyone, good afternoon. Thanks for joining us today on the Denton's Labor Spotlight Series webinar. It is the season that Santa is making his list and he's keeping an eye on all of us. So we thought it would be appropriate to theme this webinar on when it would be proper for Santa to be watching his elves in the workshop, and do those elves have any expectation of privacy while they're there? And so joining me is my associate, Emily Kroboth. And as mentioned, we're going to be talking about privacy law in the unionized workplaces. And the focus is going to be on the use and implementation of video surveillance. There are other ways that privacy intersects with the workplace, but we wanted to do a deeper dive today on just this one topic. We're also going to talk about some jurisdictional issues that may arise with respect to how unions may complain about the use of video evidence. Emily's going to give a bargaining trends update, which we try and incorporate into each one of these sessions. And then we have a little sneak peek for you regarding drug testing, which will be the subject of our next webinar. And we'll have some time for a Q&A. And it's not on here, but we're going to ask for some feedback as well from you on future topics that you might be interested in. So thanks for joining us. Okay, so privacy law overview. So just a top level review of privacy law in Canada. It's a whole other area of law, and many of you know how complicated it could be, but it intersects a lot and frequently with labor law and employment law. And there's sources of it that are both created by judges in the common law, but also through statute. And the statutory privacy law is relatively new in Canada. I would say a few decades at most. And right now, there's a federal legislation, but there's only provincial legislations in BC, Alberta, and Quebec. And absent the provincial legislation, the federal legislation, PIPEDA, will apply. So, for example, if you're in Ontario, PIPEDA does apply to private sector workplaces. However, it has very few applications or teeth with respect to workplace privacy issues. So all of that legislative law has been developing, but labor law has existed for decades. And in the absence of legislation, labor arbitrators have developed their own guidance for employers and their own methods to determining when workplace privacy will be breached by employer action. And that's what we're going to be talking about largely today. Although Emily's going to take you through some specific applications of the provincial privacy laws and how they intersect with some of the labor-generated law. And while there's a lot of different issues that can arise in a workplace around privacy, such as searches, drug testing, which I mentioned we're going to cover in the next webinar, and even potentially the collection and use of employee information. The main topic where the rubber hits the road is the use of video surveillance, and particularly when the use of video surveillance can be relied on as evidence in an arbitration, usually disciplinary. We'll go to the next slide. And like I said, the issue of video evidence generally arises when the employer attempts to rely on the video recording in evidence at, for example, a disciplinary, a case disputing the discipline issued to an employee. And there's generally two schools of thought that have arisen by arbitrators. And it's a little bit of a crapshoot, to be honest, which arbitrator will follow which school of thought in terms of how this evidence should be adduced. And this is an important point because you may want to think about that before you agree to an arbitrator when you know the facts of the case already. So it's something to consider is, have you canvassed whether or not the arbitrator you've agreed to is going to adopt one or the other approach? Because one of the approaches is a lot more lenient than the other. And so the two approaches are relevancy and reasonableness. And we're going to talk about each one specifically, but the main core principle difference between those two approaches is whether or not there's a basic right to privacy in the workplace. Arbitrators who follow the relevancy approach don't have a strong belief in that there is a right to privacy in the workplace, whereas arbitrators that follow the reasonableness approach have generally adopted a view that there is some level of right to privacy while at work. So let's look at each one specifically. So the relevancy approach. So once again, this is based on the premise that employees have no standing right to privacy in the workplace, absent a specific legislation or specific language in the collective agreement. And really, arbitrators that adopt this approach are largely, I think, trying to be pragmatic. They're trying to resolve the issue in front of them, and they're looking for the best evidence that they can to decide that issue. And if you have a video recording and the video is reliable, then why wouldn't you use that? Because it's almost like being there. And so, absent a compelling reason, arbitrators who follow the approach will generally allow video evidence to be admitted. They won't allow it typically where obviously the CBA, the collective agreement, expressly prevents the employer from relying on it. And we're going to look at some cases where that occurred, where there's some form of privilege that would otherwise apply. So for example, the recording is a video recording, but you have audio and it shows the union president speaking to his or her counsel. That would be social client privilege. Obviously, you couldn't override that. And then otherwise, where the admission of the evidence would harm labor relations. And this is a little more amorphous, but arbitrators tend not to love situations where a video is recording a griever getting advice from a union president or a union steward, or even a private conversation between, for example, the LR manager and the union steward about how something is going to happen. Because arbitrators want to foster those sorts of discussions because they lead to resolutions of disputes, early resolutions of disputes, which is the whole point of an arbitration process. And the view is if you're going to allow video of that, then it's just going to quash those conversations. They're not going to happen. So once again, very practical view on why we might not want to rely on that video. So on the next slide. And so the questions that an arbitrator is going to ask is the disputed evidence relevant? So very basic. Is the video capturing the events that are in question regarding the misconduct that's been alleged by the employer? Is the evidence reliable? This is probably the most important one. And it really goes to, are you capturing the full scene? Is it actually going to be helpful in making a determination? Because that's the whole point. So I've had cases where a camera's only captured a forklift, for example, doing the one thing that we're concerned with, but then we lose image of the forklift when it turns a corner, and the griever is able to say, well, when it turned the corner, this is something else happened, and it explains everything. So in those cases, an arbitrator might think, well, without video of that, we shouldn't allow the video of the other thing. And so that reliability, and obviously as we go forward with AI technology and the ability to modify video, that will be another concern with regards to video evidence as has been doctored in any way. But we're not really there yet, but I imagine that will come up in the future. And then lastly, does the prejudicial effect of the evidence outweigh the probative value? And this concept really arose out of criminal law. And a good example would be, in general, about evidence is if you had, a griever doing something like smoking in the workplace and you fired them for it, and there was a pattern of that behavior in the past, could you rely on that pattern of behavior? So there's some prejudice there because that past behavior generally shouldn't be relied on for the incident in question, but it shows a pattern. It's proof that the conduct was performed. So that's the prejudicial effect of sort of relying on extrinsic evidence or evidence that's outside of the current situation. But the probative value is quite high in that we have a pattern. So it's an example. Each case is going to turn on its own examples. Okay, so the reasonableness approach is probably more common than the relevancy approach, or it's more dominant. And it's based on the premise that employees do have some kind of right to privacy in the workplace. And it definitely seems more prevalent outside of Ontario and jurisdictions that have privacy legislation. And when determining admissibility, an arbitrator is going to consider, was there a reasonable ground to conduct the surveillance in the first place? And that test is objective. So it's not whether or not the employer had a subjective belief that it was appropriate. It's would a reasonable person think that the camera should have been turned on the employee at that time. And then was the surveillance itself conducted in a manner that's reasonable? And arbitrators who adopt this approach generally don't support continuous monitoring or surreptitious monitoring of employees. And so this is where you'd see, if the video was being shot in a bathroom or a break area, an arbitrator is going to be less likely to allow the evidence in because maybe that wasn't conducted in a reasonable manner. So we'll see some more examples of this. So what's reasonable will depend on the context, and some of the factors that are considered are the basis that the employer had to suspect the employee in the first place. So was there a grounds to initially turn the camera to the employee or go to the videotape and review the videotape? That's probably the most important factor, as opposed to, was the video just being monitored looking for misconduct of any kind without any prior suspicion? The nature of potential harm to the employer's enterprise, it's a common balancing that we see in labor relations. We look at safety-sensitive workplace. There's a heightened expectation that the employer can be more invasive in terms of ensuring health and safety. The degree of impairment to the trust factor, and this really goes to what the work environment was like and the relationship is like in terms of independence. Are we able to monitor the employee in other ways, et cetera? The availability of other means to collect the information, and the degree of intrusion caused by the particular surveillance method. All right. So the active monitoring question is one that comes up frequently. It's this issue on, and we'll look at a case about that, whether or not you have to have some particular incident and then go to the tape and use the tape to bolster an existing suspicion, or whether or not a manager could sit in front of a video camera and just watch the tape all day until he sees an employee make a mistake. Generally, arbitrators are not supportive of that latter approach. As we mentioned, that's the relative approach where it's measured against whether or not it was reasonable in the workplace to gather the information and observe the tape. But arbitrators are going to consider what the collective agreement says. That's usually the guiding answer. If the collective agreement allows it, it's allowed. If it's not allowed, it's knocked out. If the collective agreement's silent, then the arbitrator will turn to whether or not that monitoring was necessary due to any workplace issues such as theft, vandalism, sabotage, that sort of thing that's ongoing. And generally, arbitrators find that constant monitoring isn't necessary. Okay, next slide. Okay, so in general, some tips in terms of getting video evidence into an arbitration or accepted at an arbitration. The evidence needs to be relevant and probative. That's going to be probably a given. We wouldn't want to rely on it probably otherwise. We can't be violating the collective agreement in the collection of the evidence. There generally needs to be a legitimate reason to collect the video evidence in the first place and to have watched it. And the method of collection was reasonable. Now, we're going to talk about some tips on how to make sure you check these boxes at the end. But these are the main boxes you want to get to. So let's look at some cases and some practical examples. So in this case, OPSU and the Ministry of the Solicitor General was a case sort of cameras in prisons. And there was a lot of jurisprudence about this. It's still ongoing because obviously in prisons, there's a need for security cameras and they're everywhere. And there's a dispute between the union and the government on whether or not those cameras should be used for performance monitoring. So in this case, the video surveillance was reviewed as a result of an inmate's death. And when that review was happening, the managers realized that guards weren't completing their shift changes properly. And in response, the employer conducted further spot checks by video. And the union grieved. And the arbitrator agreed with the union that the company couldn't rely on this video for the purpose of discipline. And really, that decision was derived from 2 points, both probably freestanding. One is the collective agreement expressly prevented the company from relying on the video for supervising, as a replacement for supervising or managing, or as a means to evaluate employee performance. So clearly, in this case, they were breaching that. But the arbitrator also found that the video wasn't necessary, and that sort of spot check could have happened through physical supervisors or managers going through the workplace and seeing whether or not employees were properly doing their shift changes. So on both grounds, the government lost on that case. So good takeaway, obviously the importance of the collective agreement, but also this idea that if you have a better way that's maybe less subject to being challenged, i.e. having a supervisor or manager directly observe the conduct, that might be the better approach for employers to take in terms of getting that evidence before the arbitrator. Okay. Okay, so this is an LCBO case, and kind of a funny one. The aggriever in this case was terminated after it was found that he was basically swiping his wife's Air Miles card whenever there was a customer transaction going through, or I guess sometimes. And the company was able to use video after it had an initial suspicion to go and confirm that this was actually happening. And the union objected to the use of the video surveillance, but the arbitrator refused the union's objection. And the main basis was that in that environment of a retail store, the arbitrator believed there was a reduced expectation of privacy on the employee's part. And therefore, that balancing between whether or not it was reasonable to intrude on the privacy or whether a privacy right existed, and the employer's interest in protecting its property in this case and preventing misconduct, that balancing weighed in favor of the employer. So let's look at another case. Okay, so we've got a couple of bus cases next. So this is a case, the MTB Canadian Bus Inc. case, which was in Barrie. I think it was the Barrie Municipal Bus Service. And in that case, the griever was discharged following a complaint from a passenger that he was speaking vulgarly and having inappropriate conversations, again, about his spouse. I don't know if it was the same person. This was their second job, maybe, but he's complaining about how his wife convinced him to use the Air Miles card. But anyways, they reviewed the recordings that were in the bus, because most, as we know, the TTC and any sort of public transit has video recording in it. And they were able to confirm this customer complaint was accurate. But the union argued that the surveillance in the bus was only meant to be used for safety or security reasons, and that it didn't apply to these sorts of circumstances where it's just strictly the behavior or conduct of the operator. And in this case, though, the arbitrator found that the use of video was a pre-existing technology. So the collective agreement did have language that prevented the use of new technology in the workplace. But interestingly, the arbitrator found that the video technology predated that inclusion of that language in the collective agreement. So it wasn't considered new. And so the arbitrator found it was a bit of a loophole to allow that video evidence to be used and didn't apply the language in the collective agreement. I think it goes to the point that it's not just enough to have language in the collective agreement, it's what that language says, and has to be a appropriate breadth, or else it could be worse. You can actually limit yourself, and we'll see that in the next case, which was a Niagara Falls transit case, where in this case, the employer was reviewing video evidence totally unrelated to employee conduct. It was a slip and fall claim by a passenger, I believe. But while they were reviewing that evidence, they saw the employee, the bus operator, tampering with the video camera, mishandling cash, and using a handheld device while behind the wheel of the bus, which were all big no-nos. And the employer issued a 3-day suspension, which seems a little late to me, but anyways, based on all of that, and relied on the video evidence. And obviously the union grieved that. And in this case, that grievance was upheld because the collective agreement specifically said that the video cameras in the buses were only to be used for security purposes. And this clearly wasn't security related, although I'm sure the employer argued that it had something to do with health and safety. So it shows you that overriding, we need to make sure our collective agreement language is pinned down on this if we want to rely on the cameras as evidence. Next slide. So I'll turn it over to Emily.
Okay, hello everyone. So now we're going to go through some of the differences in the other provinces outside of Ontario that do have private sector privacy law applicable to employees. So in British Columbia, they have the Personal Information Protection Act, and this imposes several obligations on employers respecting the collection, use, and disclosure of employee personal information. So, for example, employees need to be told that their personal information is being collected. Any collection, use, or disclosure needs to be reasonable for the purposes of establishing, managing, or terminating an employee relationship. And the personal information that is collected or used in any manner by the employer must be appropriate in the given circumstances. So, additionally, consent is typically required for the collection of any personal information. There are limited exemptions, although they're pretty narrowly construed. So, an exemption would be the employer is only collecting as opposed to using or disclosing employee personal information. Consent could compromise the availability or accuracy of the personal information, and they're doing that in the context of an investigation or a proceeding, or the collection is otherwise authorized by law. Next slide. So within this context in British Columbia, there are some best practices for video surveillance initiatives, and this is published by the British Columbia Office of the Privacy Council, or Office of the Information and Privacy Commissioner. And most importantly, what's required is a surveillance policy if you are looking to implement video surveillance in the workplace. And that policy needs to address several things. So the rationale and purpose of the surveillance, how monitoring and recording will be in effect, how those recordings will be used, how long they'll be retained, if and when they'll be deleted, and a process for when there is unauthorized access or disclosure of those video recordings. And it's also recommended that employees be advised that they'll be captured on video prior to implementing any sort of video surveillance. Next slide. So looking at video surveillance and grievance arbitration, essentially, labor arbitrators will weigh the employee's stated purpose of the video surveillance practice against the employee's privacy interests to determine whether or not a policy is reasonable. So whether there's an actual need for video surveillance in the workplace, if it's used in a reasonable manner, whether there are any reasonable alternatives, like what Russ mentioned earlier, can just spot checks be done in person by a supervisor, or any other relevant circumstances in each situation. Each one of these situations will turn on their own facts, so it's highly context dependent. But a recent example of a British Columbia case where the introduction of video surveillance was considered by an arbitrator is Reen Enterprises Ltd, and this is a very recent 2024 case. So in that case, the arbitrator considered whether there was a bona fide need for video surveillance, and they determined that safety and security reasons are bona fide reasons. And they considered whether the surveillance was being implemented and utilized in a reasonable manner. And they assessed where the cameras were placed, how many were used, the time of day, and whether the cameras was recording just video or audio and video as well. So like what Russ mentioned earlier, certain arbitrators don't like certain conversations being picked up because it would have a chilling effect on negotiations and early resolutions. And then other reasonable alternatives were considered as well. So, and that may include other forms of monitoring or the practical availability of anything else that could help establish the stated purpose of the video surveillance as set out in the video monitoring policy. Next slide. So moving on to Alberta, and Alberta and BC have very similar privacy legislation. So theirs is very creatively also called PIPA, and it governs the collection, use, and disclosure of personal information by private sector organizations, just like BC does. Personal employee information is designed, or rather defined, to include personal information relating to an individual and reasonably required by an organization that is collected, used, or disclosed solely for the purposes of establishing, managing, or terminating an employment or volunteer work relationship, but doesn't include personal information that is not about an individual's employment. And failure to comply with this type of privacy legislation in any province with privacy legislation could lead to several consequences, including fines and potential lawsuits. Next slide. So looking at the issue of video surveillance and grievance arbitration within Alberta, to determine whether the purpose of video surveillance is reasonable in accordance with Alberta's version of PIPA, courts and labor arbitrators have adopted a balancing approach very similar to Ontario as well, but they'll look at three factors. So is there a legitimate issue that needs to be addressed specifically through video surveillance? Is the video surveillance likely to be effective in addressing that issue? And was the surveillance conducted in a reasonable manner? Also, importantly, employers should be obtaining consent, which includes consent to collect privacy information, which includes information about an identifiable individual, and provide notification to employees prior to introducing that. Next slide. Okay, so looking at a recent Alberta case, essentially this labor decision emphasized that employers need to balance surveillance needs with employees' privacy, as well as being transparent, reasonable, and legally compliant in their practices to avoid any unfortunate outcomes like lawsuits or fines. So the issue in this case was whether Sobeys could install surveillance cameras in an employee's lunchroom, given that employees, they had to eat lunch there, they had to take their breaks there, there wasn't really another alternative available to them. And in this case, the video surveillance was deemed reasonable, but Sobeys was required to be a bit more transparent and inform employees that they were being monitored by video. And that can be done in several different ways. So you could put up signs, make updates to policies or handbooks, any sort of communication to let people know that this is happening. Next slide. And finally, ending off with Quebec. So looking at a recent, relatively recent case that considered this issue. So in this case, the employer installed cameras to for the stated purpose of ensuring safety and preventing theft. However, the tribunal concluded that the employer's decision was justified in these specific circumstances because the surveillance was proportionate to ensuring security and didn't infringe workers' rights unduly, particularly because the employees were informed in advance that this video surveillance was happening, which reduced the impact that the surveillance had on employee privacy. Next slide. And at this point, I'll hand it back to Russ to tackle the jurisdiction issue.
So an interesting issue can sometimes pop up when there's complaints around privacy, and it's whether or not a union or an employee has to bring the complaint through the grievance and arbitration process, or whether they can go to, say, the privacy commissioner and try and get their dispute resolved in that way. And that's what happened in this Eastman and CP Rail case in 2024. And my understanding is the case law isn't entirely settled on this. So there's no black and white answer. In this case, I think it accentuates that, but it's just something to keep in mind when you're proceeding, that there is a risk that there could be this other avenue that unions or employees could take. And in this case, the union sought to bring a complaint regarding the use of video surveillance to the federal privacy commissioner. So that would be under PIPEDA because rail is governed by federal legislation. Relying on Weber, which is sort of a seminal case, some of you may be familiar with that, Weber and Quebec Hydro, I believe it was, basically where the Supreme Court of Canada found that where a dispute in the workplace arises from the collective agreement, the terms of the collective agreement, either implicitly or expressly, which is kind of interesting for this decision, where that happens, the jurisdiction to deal with the complaint falls exclusively with a labor arbitrator. And we traditionally rely on that case quite frequently to say, for example, an employee can't bring a wrongful dismissal claim against their employer where they unionized because there's no jurisdiction of the court. The court has to cede jurisdiction to a labor arbitrator. So that case, Weber, is quite common in our practice. But in this case, the Federal Court of Appeal applied that to this situation where the rail company was trying to say, no, you have to go to a labor arbitrator. And interestingly enough, the federal court found that this dispute around the introduction of cameras didn't actually arise out of the collective agreement because there was no specific language in the collective agreement that tied the use of the cameras to any negotiations. I don't know if I agree with that because I think the Supreme Court said it should be, express or implied, and these cameras were used for discipline, which I think implicitly ties into the collective agreement. But that's what the federal court found. And it's not that different than courts finding that employees can go outside of the labor arbitration realm to the Human Rights Tribunal, for example. So it's a similar concept. Ultimately, the federal court found there was not an intrusion of privacy in this case, and they overturned the privacy commissioner's decision that there was. But the important piece is if you want to forestall these sort of side attacks where someone might go to a privacy commissioner, you actually do need to include language in the collective agreement that would tie the use of video to the negotiations or bargaining. All right, next slide. Okay, so I think we're going to look at best practices, and this is really how we tie it together, all the information we've garnered. So first best practice is in bargaining. It's to negotiate the use of video surveillance into the collective agreement. And that, like I said, helps you ensure that any dispute goes to a labor arbitrator, which we generally prefer. But when we do that, we need to make sure that it's scoped properly. So the purpose of the surveillance is broad enough that it's going to capture any disciplinary purpose or other purpose we might use for it. So agreeing to language that says, for example, the video will only be used for security purposes is not great. It's going to tie our hands a lot down the road. So that would be a contentious piece in bargaining. And the next best practice would be notification. And this is a really important one. And it goes to some of the questions that have been posed. We'll get to some of them at the end, I'm sure. But where you've given employees notification that there is surveillance ongoing, that is seen as something that will reduce the employee's reasonable expectation of privacy. So when you look at that balancing in the reasonableness approach, the employee's expectation of privacy in the workplace is reduced. And so we don't have to throw as much on the importance of the interest in the employer pile to really come to a level where the employer wins out. So, one of the questions was the use of tracking devices and cameras in vehicles and whether or not employees should be notified of the use of that. Definitely. Because once again, that's going to reduce their expectation of privacy while they're in the vehicle, which will help us in arbitration. Next best practice is to consider alternatives. So yes, you might have video. That's great. And often it is the best evidence, but it might not be the easiest to get into evidence, if that makes sense. So if you can find a way to get the same information, but using a witness, a supervisor or manager who goes and physically sees the thing, it's a good idea when you're in that disciplinary investigation stage to go do that because we can't make that up after the fact. And if we have both, then if the video gets knocked out, we still have the first party eyewitness account, which is the gold standard. Next slide. Okay. So otherwise, best practice would be to generally minimize the intrusions on privacy. So I think this is only monitor in response to incidents and be able to demonstrate that you had a reason to go and look at that video in the first place. If you don't need a video camera pointing at the washroom, don't have the video camera there. If you don't need a video camera in the break room, don't put the video camera there. So Think about that when you're installing the video cameras and where they need to be, and don't be overzealous, because that can put you in a position where you've crossed the line and you've imposed too much onto the employee's expectation of privacy. Policy implementation, that's an obvious one, to have policies in place. Sometimes they're required by statute, or we saw some of the privacy legislation required it. And then periodic reviews of what you're doing with privacy, so things can't sort of spiral out of control where you're adding more and more cameras. Great. So I think we got to the next slide. Right, so that wraps us up on the privacy issue. We'll circle back to it with some of the questions. I think we'll have time. I'll turn it over to Emily to talk about bargaining trends.
Thanks, Russ. So every webinar, we try and take a few minutes just to look at the current trends at the bargaining table. All this information is sourced from Collective Bargaining Ontario. So if you have an interest or a further interest, then that's all publicly available there. But just starting with the next slide. So I think we've looked at this chart every webinar, this specific chart every webinar since the series started, and it just gets more interesting as time goes on and we collect more data. So this is a snapshot of wage increases in both the public and private sector from Q1 2020 all the way till now, which is Q4 2024. And as you can see, back in 2020, wage increases were tracking roughly around that 2% target inflation rate. But as we carry on into 2021, 2022, you can see those wage increases steadily creeping higher, coming to the highest point in the last 4 years, most recently in this Q4 2024. With private sector increases reaching that 6% level, which is a lot more than what we've seen in the past. The public sector has been trailing behind the private sector, as you can see here, kind of creeping back down at 2.9%. And just keep this difference in wage increases in mind as we look at the next few slides, because I think we can kind of glean how all of these different areas of bargaining can kind of tie in together. So moving to the next slide. So this is a snapshot of how settlements were reached in 2024. And as you can see, 72% of settlements were reached through arbitration, with mediation and conciliation and direct bargaining trailing behind at a pretty big distance. And there were almost no work disruptions in 2024 at that smaller rate of 1.2%. Arbitrations are not that common in the private sector. They're more so common in the public sector. And I think looking at those wage increases, particularly from 2024, we might have an idea as to why wages are still very much a big issue at the bargaining table. We've been talking about a recession for years now. Several conversations around grocery prices have all been very, very much at the forefront of the public's mind. So I think the fact that many resolutions were only reached through arbitration as opposed to direct bargaining or mediation is a good indication of how much of an issue that has been recently. So jumping to the next slide. And this is a snapshot of how long negotiations lasted in 2024. So you can see in the private sector, negotiations were wrapped up fairly quickly. So roughly 52% were wrapped up within 1 to 3 months. And we can glean that that's because there were further concessions on wages. And that was the main issue at the bargaining table. And a resolution was reached fairly quickly because concessions were made by the employer on the wage piece. However, looking at the public sector, we can see that roughly 65% of negotiations lasted more than 12 months, which is a very long time. And again, reflecting on that 2.9%, average wage increase might be an indication that that was a hot button issue too, but fewer concessions were made on that end. Next
Yeah, I think
slide.
maybe I'll just jump in on that too. One of the issues with the public sector has been there's been a lot of wage restraint legislation, at least in Ontario, and a lot of that came to the head in the last year or year and a half, and left a bit of a wake. How do parties resolve issues where there was wage restraint legislation in place, then it was overturned, found to be unlawful? How do the parties go forward? And that's how you get into this, interest arbitration, extensive use of reliance on that, which is common, as Emily said, in the public sector already. But it probably really dragged that out because they had those legal issues to resolve.
Okay, and then just taking a quick look at how work disruptions in 2024 compared to previous years. So work disruptions, meaning strikes, and you can see that there was a huge jump in work disruptions in 2020, but that has since leveled off with roughly in the same ballpark. Year over year in both the public and the private sector. So we haven't seen that large jump in a while, which is helpful, but again, perhaps an indication of sorting out those wage issues and further concessions at the bargaining table. And I will hand it back to Russ to give us a sneak peek into next time.
Great. So we're always listening to feedback, and we're going to ask for some feedback from you at the end on future topics. But one of the topics that's come up is drug testing in unionized environments. And April Costin, who's in our Calgary office, is a national expert on that. So she'll be joining us next time, probably in February, for that topic, which we're looking forward to. But there was a recent case, we go to the next slide, that we wanted to bring to everyone's attention. The purpose of this webinar is not usually to cover the latest and breaking topics in labor law. One, there's usually not that many. The law is very slow to develop in labor, which is not a bad thing. But two, we wanted to focus on fundamentals here. But this case, we wanted to bring to your attention because I think it's pretty exciting and interesting. So basically, the Federal Court of Appeal heard this case between the Canadian Nuclear Safety Commission and the Power Workers Union about random drug testing and pre-placement alcohol and drug testing. And the union challenged that testing on the basis of a number of grounds, including privacy and charter of rights and freedoms. Pretty standard stuff. We've seen this case over and over. But the really interesting thing is the Court of Appeal found that workers who are in a safety-sensitive work environment have a diminished expectation of privacy because of the nature of their work and the unique environment where the work is being performed, which is kind of earth-shattering in my view, because previously what arbitrators are requiring is employers to show that there's a problem in the workplace. You have to show evidence that there's a drug problem, for example, or an alcohol problem. And that caused a lot of employers to bristle because the question is, it's basically saying, well, show us people getting hurt, show an accident, a major accident happening. And I think the Federal Court of Appeal got it right here. And they said, you're in the nuclear world, you can't wait for an accident to happen before you have enough proof to roll out one of these policies. There has to be some sort of expectation that these sorts of policies are more likely in this type of environment. So I think they hit the nail on the head on that, which is great to see. So I'm sure April will talk in depth on that case in February, but we wanted to make sure everyone was aware of it, especially if you're working in one of those safety sensitive environments. Nuclear, obviously, oil and gas, transit potentially, manufacturing, chemicals, hazardous chemicals, those sort of things, definitely can be considered safety sensitive. Mining. Great. Okay, so we have a bit of time, and there's a few questions here. So maybe we'll switch to some of the questions and try and answer them. If you have more, feel free. We might not get to all of the questions, so we'll try and get back to you if we don't answer it live here. But I think one of the first questions which I thought was great, was from Joan, and she said, "To what extent are principles you were going to discuss applicable to non-union workplaces?" So it's actually pretty interesting. In Ontario, at least, where there's no privacy legislation, these principles are completely unapplicable to non-union workplaces because employees effectively don't really have a privacy right in Ontario. Um, the only privacy right they would have would be a civil right, which is called the intrusion on seclusion, which is a tort, basically a civil lawsuit that someone could bring if there's a really egregious violation of personal privacy. And we really haven't seen one of those rise out of workplace issues. And it certainly wouldn't come from, having a camera set up over, a cash register. It would take having a camera set up over, the employee washroom. That might do it, right? So there's very few limits on employer conduct in the non-union environment. And it goes back to what I was saying about how a lot of the law has been created by arbitrators, and it only applies in that context. Otherwise, as Emily talked about, if there's provincial legislation that applies, then yes, that would generally apply to non-union and union employees alike. So all of those points that Emily raised would likely apply in non-union workplaces, unless Emily could disagree with me on that. No, okay, great. Got it right for once. Okay. There's another great question from Derek. Is there a distinction of how arbitrators might look at video cameras which are external to a facility, i.e. in a parking lot, versus inside a facility? So that's a good question. And yes, definitely. I think generally an arbitrator is going to view that there's a lower expectation of privacy outside of the facility. So in the parking lot, for example, than inside. It might not be a big change, but there will probably be a lower expectation of privacy. And I've seen personally in some cases where employers can have a better argument too that the video cameras are needed externally because you might be trying to prevent theft or people trespassing on property. So there's a better excuse to even have the video cameras set up in the first place. So great question. Emily, did you want to grab one of these questions? I can do another one while you're looking for one. This question here, is there a difference between using an arbitrator versus presenting a case at the Human Rights Tribunal? That's a good question. So generally a case like this wouldn't go to the Human Rights Tribunal around videotapes unless the videotaping was done in connection with a protected ground. So potentially maybe with respect to monitoring someone who's being accused of faking a disability, there could be some video monitoring in that case. So that could go to the Human Rights Tribunal. But in general, parties prefer going to labor arbitration because few reasons. It's cheaper. It's way faster to deal with, which can be good and bad. The speed thing can be good and bad because the Human Rights Tribunal takes forever, which can sometimes be a big benefit to an employer. But the main thing is a labor arbitrator has to be selected by the parties. And something that maybe isn't appreciated sometimes is that in order to be agreed on the parties, they have to be seen as neutral. They have to be seen as trustworthy and knowledgeable. And if you have an arbitrator that's going to take a really black and white or harsh stance against you, you're not going to agree to use them again, and other employers might not. So it's definitely employers prefer that venue because it's literally friendly. It has to be friendly. It kind of depends on it. It's friendly for both sides, but you're less likely to get somebody who you have no idea of what they're going to do. There's way more predictability in the arbitration realm.
So we have a question from David, and David asks, in BC or Alberta, would having video capturing an employee completing their job tasks be impacted by law protecting their personal information? And does their conduct on the shop floor constitute personal information? So what we've seen from the privacy commissioner's stances in each of BC and Alberta is that yes, it does. And because of that, there is a requirement to introduce a video surveillance policy if you choose to do so. And in the context of arbitration, arbitrators will still apply that same analysis of was the video surveillance reasonable? Was it required? Did it accomplish what it set out to do? So definitely image capture in the workplace is considered personal information.
Great. I think it's Dean said, well, intended purpose of surveillance is for safety and security of employees and clients. If a complaint was lodged about conduct, could it be seen appropriate to use surveillance in that case? So I think it goes back to some of those decisions we looked at, the arbitration decisions, and it's going to depend largely on what your collective agreement says. So as you remember in that one Berry case, the collective agreement allowed or didn't prohibit the use of video that was originally installed for safety or security on the bus, but then the employer was able to access and use it for another purpose. Now, that's okay. The collective agreement didn't say that was not allowed. It was otherwise reasonable. The employee was aware they were videoed. So I think that reduces the expectation of privacy. So when you look at that, well, relevance is certainly relevant, but reasonableness approach, it would be seen as reasonable. But then we saw then the Niagara bus case, Niagara Transit case, that the collective agreement specifically called out the use of video and said it was only to be used for security purposes. And that really tied the hands of the arbitrator to say, no, you can't rely on this evidence, and they threw it out. So the intended purpose is a factor. I think the overriding issue is what is the permissibility of using video broadly? And why did you go and look at the video in the first place? Was there a reason to be suspicious? And that all goes to that reasonableness question that someone else was asking, what's reasonable? And once again, it goes to how the video was collected. And that would include, where the cameras are pointed, how often the video is viewed, what's the purpose of the viewing, and also whether or not employees were aware of it. Did they have an expectation of privacy that would outweigh the employer's interests? That would make it unreasonable if it was the case. And, like an extreme example, but a good one for demonstrating the point is the bathroom. Yes, it would be, there's probably a purpose to having a camera over every toilet stall in every workplace. There's someday you will catch something happening that's bad or unsafe or something. But that, if you balance that interest against an employee's privacy interest in the toilet, that would be very high, I would say. So it's a good example of how you're getting, there's some benefit for the employer, but it's not sufficient to outweigh the privacy interest of the employee. Maybe one more question. Emily, do you?
Yeah, we have a couple of Ontario centric questions. So from Susan, is video surveillance policy required in Ontario for non-unionized workplaces? No, this is just expressly required in BC and Alberta. And then Bobby pointing out these cases are all based on union environments. How do they compare to non-union? And essentially, as Russ mentioned earlier, there's a lot more flexibility in a non-unionized environment with respect to collecting this type of information.
Especially in Ontario. Yeah, but in other provinces, you have the law that will apply, like the legislative law, but otherwise, fair game. Great. Okay. Well, I think we're on time here. So thanks for joining us. I think that brings us to the end. And we look forward to having you join us on future webinars. Definitely invite friends and colleagues who may find this topic interesting. And feel free to reach out if you have any questions or concerns. Thanks again.